This poorly documented case begins in March of 1811 in New York when one party, Sturges, agrees to lend money to another, Crowninshield. Terms are negotiated and the contract is signed. In April 1811, the New York State Congress passes a law stating that people declaring bankruptcy may not be held accountable for their debts on the condition that they surrender all their property and possessions to the state, to be distributed to the people they owe money to. This law being passed at a place and time when people who could not pay a debt were usually thrown in jail. Crowninshield, later not being able to pay back the money he borrowed, wanted to avoid jail, so he took advantage of the New York's law and declared bankruptcy, releasing him from his obligation to his creditor. Finding that Crownинshield's property was not sufficient to repay the debt, Sturges sued in a Massachusetts state court to get the money from the debtor. The Massachusetts court upheld the New York law, saying that Crownинshield's obligation was satisfied. But Sturges was not satisfied. He appealed this case to the John Marshall Supreme Court in 1819. The first thing the court had to consider was Article 1, Section 8 of the Constitution, giving federal Congress the power to pass uniform bankruptcy laws throughout the country. The question of whether states were allowed to pass bankruptcy laws in the absence of federal law was not clearly answered by the court in this case. More on that later. The second thing the court had to consider was, of course, the contract clause, and whether New York's applying the new bankruptcy law to contracts signed before the law's passing was an impairment of that contract. The court ruled that yes, allowing debtors to get out of that liability by surrendering their property to the state was a violation of the contract clause. However, interestingly, Marshall upheld the part of the law abolishing debtor prisons, stating that they are merely a method of enforcing obligation to contracts, and did not interfere with the contract itself.